Good afternoon, everybody, and welcome. We're a couple of minutes behind, but this is a fairly informal gathering, it would seem. We're here to discuss HB 1061 relative to Midwifery Council. And I'm going to take a moment. Well, before I even start, I want to please remind you that even though it's an informal thing, it is streaming. And so when you step up to speak, please do make sure that your microphone is turned on. Let me go over a little bit of the history of this because we've seen a lot of bills and some of us could use the reminder, although some who this is most close to may not. Let's see, this bill first had a public hearing on January 20th of this year. And then it went into a subcommittee meeting on March 1st, followed by an executive session on March 7th, during which an amendment was proposed and passed 18-1. And amongst the other things that amendment did, it reinstated midwives as a majority on the board. It went for a vote, ought to pass as amended, and that vote failed by a vote of 8-11. And then the motion was made to send it to interim study. That motion passed 19-0, and that's what brings us here today. It was placed on the consent calendar, passed in the House. So I'm going to and this may be a little bit different than some of the interim study subcommittees you've attended because this is the first one that I've chaired, but I'm going to try to cover all the territory as briefly as possible. First, I want to just give a brief summary of the testimony that was provided in the public hearing, and then I'd like to give an opportunity for anybody who has an interest in this bill, whether on the committee or in the public, to speak. To summarize briefly, the public testimony for the bill was all in opposition, and that's just a fact. We had Heidi Reinhardt, who was an OB-GYN from Keene, Sherry Stevens, board chair, a variety of others. The proponents of the bill were the committee members, the co-sponsors, and they spoke and made their support for the bill clear. They'll probably hear some more of that today, especially since we're speaking about the amended version. My recollection is that there were two major concerns about the bill. One was that it converted the board from a decision-making body to an advisory body. And the second was that from a majority of midwives on the board, it went to a minority of midwives, one OBGYN, one pediatrician. I don't recall if it was one or two midwives, and perhaps a public member. Anybody is, please feel free to correct me on that. Two, thank you. So would you repeat the
It increased the number of OBGYNs, which was very threatening to the midwives, and not at all the intent of the original sponsors, but that was the way the wording came out. So that was something, you were going to have more OBGYNs and midwives on the board. That was completely unacceptable to the profession, and frankly to myself as one of the co-sponsors as well. Thank you, Mr. Chairman.
Thank you. All right. The amendment, which was put together by Representative Pearson, remedied that situation. And let me see if I can quickly find the new makeup of the board proposed in the amendment. One obstetrician, one pediatrician, 3 midwives, And if I recall, there was some discussion of a public member, but perhaps there's someone in here who knows best and can um, correct me on that.
Chair,
Yes.
that amendment is not, was not actually adopted. The final vote was not to pass it with the amendment, but to go to interim study. So we do not need to consider the amendment.
Okay.
Unless you want to.
Yeah. Then, no, thank you. I was unclear on that from the notes, to tell you the truth. The sequence, I got the sequence one out of step.
But officially, the vote to interim study kind of wipes out the amendment.
Yes, that's correct. Thank you. Because on the docket, it does not make mention of the amendment. So we discussed the amendment, but we did not pass it. And then we voted 18 to 1 or 19 to 0 to move it to interim study. At this time, I guess I would like to ask anyone who's interested in speaking on behalf or in opposition to the bill and to make a recommendation about what might be done. I would be pleased to hear it now. So if anybody would like to step forward, you're welcome to now. Thank you. Don't forget the microphone, and please state your name and your official capacity for the clerk.
I'm Sherry Stevens, and I am the chair of the New Hampshire Midwifery Council. And so I think this was, oh, sorry. I think this was distributed to the members before, but it wasn't read. This is the official letter from the council. So it's, my name is Sherry Stevens. I am a chairperson of the Midwifery Council, and I'm writing on the council behalf. The Midwifery Council is opposed to HB 1061 because it fails to address fundamental concerns. Better? It was on. Okay. This bill seeks to make the Midwifery Council simply an advisory committee to the Executive Director of the Office of Professional Licensure and Certification. As advisory committee, we would have no independent ability to make changes. Instead, all actions would be initiated and decided by the OPLC Executive Director. The Midwifery Council has worked to cultivate a fundamental working relationship with OPLC staff and administration. However, we cannot be guaranteed that the agency will continue to be cordial and collaborative in the future under different leadership. If this bill becomes law, the Midwifery Council would lose its ability to remain the clinical experts who conduct administrative rulemaking, draft and proctor examinations, that is actually changing now, and initiate investigations and impose discipline. The Midwifery Council consists of a licensed obstetrician, a licensed pediatrician, 3 midwives, and a member of the public. That's what it currently is. It is improper for the legislature to give the OPLC Executive Director regulatory authority over the practice of midwifery in New Hampshire with discretionary power to disregard the expertise of experienced midwives and physicians' knowledge about midwifery practice or profession. In order to preserve professional midwifery autonomy, the Midwifery Council, and to achieve the goals of functioning within legal barriers, we would endorse amending the language of this proposed legislation to reflect that the Midwifery Council continue to act autonomously with consultation of the Executive Director of OPLC. We respectfully request that you reject HB 1061 or, in the very least, amend the bill to charge experienced midwifery professionals with input from physicians who are knowledgeable in midwifery to make critical decisions regarding the practice of midwifery in New Hampshire. The Midwifery Council welcomes the guidance and oversight of OPLC Executive Director to remain within legal bounds and prudent administrative practices. Thank you for your consideration. Currently, the board makeup is 3 midwives, an obstetrician, and pediatrician that have experience working with midwifery practices, and a member of the public. And the sorry, I'm thinking of my words. The amendment had taken out the member of the public, but we think they're valuable.
Right.
they-
So it kept it at 5 members instead of moving it to 6.
Right.
Um,
Which was a matter of balance, and we were
Math.
okay with that. If that were to come about, but we're very concerned with, losing the autonomy of the midwifery profession as it is. And we understand OPLC's reasoning that they had given about wanting oversight, and so we would be happy to work with them and see if we can't come to some kind of way of making oversight other than completely losing our autonomy of our profession.
Are there any questions from the committee members for Ms. Stevens? Yes?
Thank you, Mr. Chair. I was concerned that there aren't a lot of midwives in New Hampshire, and that in order to maintain autonomous, you'd have to charge excessive fees. Has the council considered what kind of technical and professional support they need to arrange to pay for?
It has not come to our attention in terms of fees or our licensure. We had in the past $200 was our fee for licensing every 2 years that we had the ability to make our fees at that time, and I believe that OPLC has changed that, and our laws, the fee got changed to 110, quite honestly, without our knowledge at the time, and that they have the ability to change those fees on us at this point. But we have not had that discussion, and that has not been brought to my attention.
Any other questions?
Well, yes,
Yeah.
and I noticed that you're in rulemaking on the scope of practice.
Mm-hmm.
How's that going?
It's going great. That's because they sunset, they go out of date, that we look at them and make changes. And the scope of practice, we need to update certain things that, as time goes on, they need to be addressed, but it's not very substantial. So our substantive, the protocols that we're looking to change at this time. It's more about getting them before they expire.
Other questions? If not, then, yes, Representative.
Thank you, Mr. Chair. I was waiting to see whether any of the other representatives wanted to weigh in on this because, as Ms. Stevens knows from a long conversation, she and I had early days on this when this bill was in the process of being brought forward, that our purpose in filing was not to handcuff midwives with regard to their autonomy. And I did apologize, I believe, during the course of the hearing with regard to that the language of the bill as it landed on the committee's doorstep included several aspects which were not certainly not my intention, and I was not supportive of them, certainly. But one of the issues is that we have been trying to change the OPLC structure, if you will, to be more successful and to be more effective. And we started with a couple of the smaller professions so that we wouldn't tackle some big profession. It's kind of like when a child starts with a small bicycle or tricycle before they try a big bicycle and are big enough for that. So one of the problems has been that with some of the smaller boards, getting a quorum when you have a small contingent of practitioners, and the advisory aspect, as it's been put forward. The intent is to have the administrative function in the hands of and the oversight in the hands of the OPLC, which is their forte. They have attorneys, rules writers, and so forth and so on. The practitioners should be in charge of the scope of practice and all aspects involving that. And the word advisory is causing lots of complications because it certainly implied to you and to many of your practitioners the idea that you were going to be only offering advice, and the executive director would have plenary authority to do everything. And somehow, can you see a way or a word that would express the partnership of the two entities, OPLC on the one hand, administratively, legally, and so forth, in your case, the midwives and their medical cohorts, the OBGYNs and pediatricians, would be on the side of the science of midwifery. And that, and neither side would have dominance over the other. Each would provide its area of expertise so that the whole operation would be more effective in advancing the cause, in this case, of midwifery. So if we can come to some kind of terms that will make that clear in the statute, and a future executive director could not take away your autonomy, would you more be inclined to this cooperative arrangement than you were initially? I think you and I understood each other after our conversation. Certainly the midwives and supporters of midwifery who came to the bill they did not understand that. And they were not supportive of anything other than the midwives being in charge, even if it was not maybe working as well as it should, on behalf of midwifery and the right of citizens of New Hampshire to go to midwives as opposed to being seen in hospitals by OBGYNs.
Representative, I would
Yeah.
like to hear the answer to that. Thank you.
I appreciate your indulgence, Mr. Chairman.
Okay.
Yes. Well, first of all, this bill as it is right now, I think what was said earlier was that the amendment to change the balance of 3 OBs and midwives is still on the table because, okay, so that's,
This bill is not in any form on the table.
Okay.
We're here to consider using this as a framework, whether we need legislation for next year, and if so, what would it consist of?
okay.
So I guess the question would be if if a new bill reflected the amendment, what would your thoughts and position be on that?
Right. So officially, what I can say that we have a vote on from the council is that we had wanted this bill to be rejected, and that if OPLC wanted to have more oversight over us, that the Midwifery Council continues to act autonomously with consultation of the executive director of OPLC. So if we were to make decisions with our rulemaking or make decisions with our investigations, things like that, that we would have to go to the executive director, and it would put us in the position of they could say yay or nay to us, and so we would still be accountable to somebody other than our group. In terms of having quorum and things like that, there are enough midwives in the state that meet the requirements for serving on the board. And at this point, it's a little bit of a process to get somebody on a board, but we've been able to fill those positions. We have the public member is at large right now because we weren't really trying to fill that position because of this all was going on. I think there are people looking to fill that position at this point, but we've not had a quorum issue, and there's enough new midwives coming in to the state and old midwives like me that are going to be done with our service soon, and there's enough coming in. So keeping a quorum of the 3 midwives and the 2 doctors and the public is fine with us. And in terms of working with OPLC, we are happy to. I mean, and right, it costs some money, and we understand that. But we were told that OPLC is coming in, and we're going to help you administratively. We've had members of the OPLC in our meetings that have kept our meeting minutes going correctly, and everybody, moving along with our agendas. And we welcome that. We've been very happy with that. Having legal counsel in on the rulemaking, and when we have investigations, they have a process there that we are doing our best to, participate in and cooperate with. We welcome that kind of help, because you're right, we're not rulemaking authorities, we are midwives. But when it comes to taking the autonomy away from our profession, the history is, like Dr. Reinhardt had said in her testimony, their profession was actively trying to wipe out midwives, and that's still true in this country. So New Hampshire's wonderful. New Hampshire's had this law for 30, 40 years in New Hampshire, where we've certified midwives. But one of the other people talked about Louisiana. They had a board just like this, and they moved it to advisory, and then it's wiped out, and they're gone. They don't have, and we think that the rules that we go under, our law and our the midwifery rules that keep us, our scope of practice keeps the public safe. I mean, if we didn't have that, there would be midwives, as they were prior to having this RSA 326D that made midwifery legal in New Hampshire. They had midwives going and doing twins, and they had midwives doing whatever they wanted. And they're certainly true in our neighbors into the south of Massachusetts. They don't have anything on their books, and those kinds of births are happening. And I'm not saying they're safe or unsafe. That's not for me to say. But that's what was happening in New Hampshire. We got our 326D. We've made our rules. What we thought was keeping midwifery as a profession and the public safe by doing that. And we are accountable as midwives to follow into that protocol. And if we don't follow those protocols, we get disciplined, right? So that's what we are doing to keep the public safe. And by certifying people, which is a process that we do, which OPLC now helps us with, which is wonderful, and by doing our rules, keeping our rules that were put in place and just updating them as needed, which is pretty minimal, and then by doing the discipline, which OPLC also has taken over and has helped us with and given us more legitimacy. If we end up, subpoena records, OPLC does that, which is better than me in my office doing that, right? We want that kind of
All right.
legitimacy. So we are really happy to work with them, but there's not another profession that, okay, that's not right. There are possibly other professions that are small boards that being an advisory committee would be absolutely wonderful, and that's just what they need, and that's all the support they need. The nursing board, the medical board, they wouldn't do that to them. They're not going to do that to them. They don't have an intention to do that to them. Midwifery is a small profession, but what we do is really important in our being able to have autonomy over that and say over that instead of just being an advisory position is extremely important to us as a profession and our clients.
All right. Thank you. Are there any further questions from Ms. Stevens? Representative?
Thank you, Mr. Chair. I will say that at one of our Committee of Conference meetings, the chair of our sister committee in the Senate suggested that she would like to see, to enable a lot of these boards to meet either remotely or hybrid. With your knowledge of the membership of your profession, do you feel that would enable you to better obtain quorums and have robust meetings?
Absolutely. The OB currently travels all the way from Keene, which is a lot for her to do, and take out of her time in her practice, and a lot of us are on call. So if I'm able to stay in my office and have a meeting as opposed to coming all the way down here, now I'm an hour and a half from my client, it would be much easier for us to meet, and we would have much more success having quorum.
Follow up.
Just follow up. And I believe, if I recall correctly, many of your members practice in the North Country. Is that true?
No, I'm the North. I'm in North. The other two midwives on the council live in Concord, and the pediatrician lives in Concord. So it's been fine for them. But in the past, we're all over the state where we live.
Thank you.
Any further questions? Representative?
Thank you, Mr. Chairman. So I want to emphasize the point that Representative McGuire, the EDNA chair, made earlier, that the bill and the amendment are both dead. Our only function is to make a recommendation, which is not binding on anybody, make a recommendation either to recommend further legislation on this subject or to recommend no further legislation. But I, as a representative, and my colleagues, anyone else in the House, is free to file a bill on anything relevant to this subject. So while the present bill is effectively dead, don't have to worry about that, we are still open to offering further legislation. So I am seeking to find some framework that will promote and support and maintain and care for the practice of midwifery. Even though my daughter was born in a hospital, I know I was born in a hospital, although I've
The
only,
question, please?
I'm getting there, Mr. Chairman. So I'm very supportive, but I think this is something that I would recommend that we work on further to make sure that we're promoting. Is this something you would be open to? It sounds like you are.
Yes, absolutely. I have honestly not sat down with, Lindsay and said, what do we need to do or what can we do? I'm open to that conversation I understand her concerns of oversight. And so I'm open to that discussion of what we can do to alleviate that problem as well. So yes, I would be willing to do that. I think that as it's been working, as OPLC has been growing and changing and organizing, and we welcome their changes that they're making, that's wonderful. And as our board has been growing and changing and learning, what we have right now could work really fine. If we need to do something else for some further protection, that's a conversation we'd be happy to have.
Okay. Unless there's another question that's unique, I don't think we're covering new ground at this point. So I would thank you for your testimony. And is there anybody else who would like to speak? Ms. Courtney?
Good afternoon. I'm Lindsay Courtney. I'm the executive director of the office. And at first, I wish to thank Sherry for coming here, for being involved, for willingness to work on, I think, what is a difficult topic. And I also wish to express that that the concerns that we have generally in the office are not necessarily specific to the Midwifery Council. So what I've observed is that, well, first off, professions, and I think this is a somewhat controversial notion in the state of New Hampshire, but it shouldn't be. Professions are not entitled to regulate their own profession. That is something that the legislature makes a decision as to what the framework should be for regulating a particular profession, whether a profession should be regulated at all. And certain states have taken different approaches. Our approach has historically been allowing active market professionals to actively regulate their own profession. There are some really good things about that, and there are some really not so great things about that. And I think that some of the concerns that OPLC has centers around that structure that New Hampshire has chosen. Ultimately, it's not up to me, obviously, to make a decision about whether there should be changes, but I do think it's incumbent upon me to bring these concerns to the legislature's attention, which is why we sought support to file legislation to move some boards to advisory. There is a concern about oversight, namely because professionals are professionals in their field. Midwives are midwives, doctors are doctors. They are not, and they shouldn't be reasonably expected to be, experts in administrative law, in statutory compliance, in regulatory compliance. As a state, I think we've grown significantly more complex from a legal standpoint. It's no longer that you just look at your practice act and okay, it tells you how to, what you need to comply with in order to meet the statutory framework. There are other statutes that come into play, statutes that you need to know about, and I wouldn't reasonably expect a professional to know, for example, 541A applies, 91A applies. Oh, I need to look at the statutes regarding labor because there's a committee that needs to be established, or 21G applies. These are things that we expect our committees and our boards, councils, and commissions to know and in order to actually comply with the statutes and rules that we have in place. But it's not reasonable for us to expect them to do that, which is why I think the office was created. I think the office was created obviously to provide that sort of administrative support to make sure that boards, councils, and commissions have the information they need to comply. But what we found is there's no mechanism for us to actually ensure they are complying with the law. So we can provide, you can lead a horse to water, but you can't force it to drink, that sort of thing. And we've run into issues. You will see another LBA audit coming out, and it will highlight a lot of issues. And there have been many audits of boards in the past, highlight a lot of issues, and it all centers around the fact that this is a volunteer job for them. This is something they come in once a month, once every quarter to do. And so I think that with this model, what we get is 60% compliance with the law. There's no mechanism to provide oversight. So that's really the basis for seeking some sort of structural changes. But there is more than one way to skin the cat, so to speak. And this, what was proposed in 1061 doesn't need to be the way. But in my opinion, there needs to be oversight of these boards, and it's not just Midwifery Council. The Supreme Court, for example, in North Carolina Dental made it very clear that when you have active market participants regulating their profession, there is an inherent risk that does play out that regulations will be put in place to keep people out and not to protect the public. And that is the purpose of licensing, is to protect the public. It's not to promote the profession. And I think that there's often a misunderstanding among many stakeholders about that. So I do think further legislation is needed. I don't know that it needs to take the form of 1061. I think other states have taken different approaches. Safety, for example, Ms. Stevens had mentioned a consultation requirement. Safety, when it had the mechanical board, had a requirement that all regulations had to be approved by the commissioner. That sort of veto power provided that state supervision. There are other states that have different models. I do think it's very important that professionals have input and some decision-making power into criteria and scope of practice. But I think that you really need to combine both state supervision, experience with administrative law and procedure, as well as individuals who have that expert knowledge in order to be successful at regulating a particular profession. So with that, I'd be happy to answer any questions.
Do committee members have a question for Ms. Courtney? Representative. Oh, sorry, Carol, you're out of my.
Thank you. Okay. I was going to ask about administrative rules. Is that what you were going to ask about? No. Okay. Ms. Stevens indicated that she's been discussing that with her committee or her council and with you. Do you agree with what she said, that you can work with her to establish the priorities in administrative rules that will help this division that you're speaking of?
Yeah, I think absolutely we can consult with the council, and we're more than happy to do that. Regarding, yeah, absolutely.
Representative McGuire.
Yes, thank you. I was actually going to ask about the fees that the board charges and what the expenses are of the office. Can you give any highlights on that?
So I don't know where Midwifery Council is at this point. I would say they're probably under 100%. That's just off the top of my head. They did have a statutory fee of 110, so we were not able to make any changes to that up until recently. And I don't know that the governor has signed Senate Bill 313, but if he does sign Senate Bill 313, that would remove that statutory fee, and we would then be in a position to promulgate rules regarding fees. That said, I've been advised not to do anything regarding fees at this time other than keep things consistent, because there were some not midwifery related stakeholders who were extremely concerned about OPLC's ability to set fees. And I was directed not to do anything regarding fees until such time as stakeholders can reach consensus on that issue through Senate Bill 313, which is kind of converted into Senate Bill 330.
Other questions? Well, seeing none, then I think we'll just move on to a committee discussion. And I'll express my opinion first, if that's not objectionable. The original bill, I think, intentionally or not, was a little too aggressive, and that's what caused the I don't want to call it an uproar, but the pushback. My inclination is, it seems like it would be reasonable to recommend that legislation be considered in the next cycle. Of course, that's almost a non-recommendation because, as Representative Schmidt pointed out, representatives are free to propose legislation regardless of any recommendation or not. But it seems that using the amended version of this bill as a framework to begin with, it would be a reasonable recommendation that it should be pursued. And I would like to ask for committee members' input on that suggestion. Representative McGuire.
Yes, thank you. I mean, I agree with you that there's some things that need to be changed in the statute and to basically to recognize the existence of the OPLC and how the council will work with it. And that's, as Representative Schmidt says, we haven't worked out the details by any means, but it does seem like something that needs to be done. And since we've been thinking about it, we should get to it before we forget.
Representative Senator Anastasia, did you have a comment?
Yeah, I basically agree that we should introduce legislation based on the amended version. There's a few changes that need to be made, and I'm not exactly sure how to do it at this time, but we can probably figure it out over the next session.
Thank you, Representative Schuett.
Thank you. I'm just expressing that I hope that Ms. Courtney and Ms. Stevens will continue their collaboration and perhaps come to us with some agreements that we can incorporate into legislation. Between all of us that are here, some of us should be reelected, and please don't hesitate to approach us with whatever agreements you can come up with that we can incorporate.
And Representative Schmidt, I saw you nodding, but would you like to add some words?
Well, I'm not on the subcommittee, so I don't have a vote, but I'm pleased with the direction that everybody is going in, that we're going to try and do what's important for the people of New Hampshire and the practice of midwifery. So I'm very pleased at the direction you're headed. Thank you.
So correct me if I'm mistaken, but it seems to me that the recommendation of this subcommittee is unanimously to recommend future legislation on this topic. Does anybody disagree with that or want to modify that statement? And if not, I'll ask for a final comment from any of the committee members. And if there is none, then I'll adjourn this. All right, thank you. Well, Carol, do we have a formal vote here, or is it more like a regular subcommittee meeting?
We could take a formal vote, but the full committee needs to vote on it, on the recommendation. So you don't have to if you don't want to.
Okay, well, it's on the record that this subcommittee was unanimous, and that's what we'll convey to the full ED&A committee. All right, thank you.
All right.
We'll close this session.